On the record, in the matter of the people of the state of Michigan versus Jordan Lee Brown, 24-02155, council appearance.
Virgin on behalf of the people, Your Honor.
Jacob Brown, on behalf of Mr. Brown.
Mr. Brown is present via polyphone from the Ingham County Jail. Today was the date that was scheduled for a final pre-trial on a assault and battery. Do you have necessary witnesses here?
No, Your Honor.
How are we proceeding?
Next would move for dismissal.
Motion to dismiss is granted without prejudice. The people do have the right to reissue this charge against you, Mr. Brown. Do you understand that? Can you hear me, Mr. Brown? Okay, I can't hear you for some, but unless you have a question for me, you're all set.
Okay.
Okay, thank you.
You're all set to go, Mr. Brown.
Yeah.
On the record, in the matter of the people of the state of Michigan versus Edgar Holter, 24-03013, council appearance.
Virgin on behalf of the people.
Good morning, Your Honor. This is the public defender, Lawrence Sutter, on behalf of Mr. Coulter, who is standing to my right.
Okay, Mr. Holter was scheduled today for a final pre-trial. This is for domestic violence. Are necessary witnesses present?
No, Your Honor, the next witness failed to appear today.
Council.
Thank you, Your Honor. This time I make a motion to dismiss.
Motion to dismiss is granted without prejudice. The people can reissue this charge against you within the statutory time frame. You understand that? Do you have any questions? We'll get you a copy of your dismissal in just a moment. Thank you. On the record, in the matter of the people of the state of Michigan versus Bradley Cross, 20-01413, council appearance.
Virgin on behalf of the people.
Jacob Brown, on behalf of Mr. Cross.
Okay, Mr. Cross has a domestic violence, let's see, it was previously an offer, quick 17.5.4A, witnesses here.
No, Your Honor, the necessary witnesses failed to appear today.
Next motion to dismiss.
Motion to dismiss is granted without prejudice. They can reissue the charge against you, okay? We'll get you a copy of the dismissal before you leave. On the record, in the matter of the people of the state of Michigan versus Michael Drodney, 24-02257, appearance please.
Virgin on behalf of the people.
On behalf of Mr. Rodney.
This was scheduled today for final pre-trial. Let's see here. It was an offer for him to plead guilty to malicious destruction of personal property with restitution. How are we proceeding today?
You understand, it's my understanding that that is the agreement that's in here today.
Yes, sir.
You have paperwork?
I have an advice of rights form. I don't think we have a plea sheet yet.
And I was under understanding you took it morally, but I can fill it out right now, Your Honor.
I'll give you advice of rights.
Okay, is it the same offer that I just read?
Yes.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, thank you. Okay, I have an advice of rights of plea information sheet. It has today's date on it. Is that your signature? Did you read this document?
Yes.
You understand all the rights here? And are you willing to give up all of these rights in order to accept the offer, which is to plead guilty to the count of malicious destruction of personal property and pay restitution?
Yes.
Okay, you understand that you have the right to the presumption of innocence. So that means you have the right to be innocent until they can prove you guilty. And you can proceed to trial and require they prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to maintain silence at your trial and not have that silence be used to prove or imply that you're guilty. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call to testify against you at your trial. You can subpoena witnesses to testify for you or on your behalf at trial. And you also have the right to waive your silence at trial and testify on your own behalf. You understand that?
Yes.
And you're willing to give up each of those rights? Yes. Is anybody threatening you to do that?
No.
Any promises being given or in exchange for you entering a guilty plea today? Are you currently on probation or on parole? Where are you on probation?
Now it's in this county. Let's
Just got transferred.
You understand that a guilty plea could potentially have an effect on your probation status? Okay, you understand that a guilty plea could result in a conviction that you may need to report to your current or future employer?
Yes.
It also could have effect on where you can travel or get immigration status. You understand that?
Yes.
Okay, as to malicious destruction of personal property, how do you plead?
Guilty.
It's because you believe you're guilty?
Yes.
Factual basis, counsel.
Mr. Drobny, on July 31st of 2024, were you at a location of and North Walnut Street?
Yes.
That it's in the county state pension?
Yes.
Well, at that location, did you cause some damage to a vehicle? I believe a Ford Flex belonging to Saul Leatherman?
Yes.
Sorry, Ford Edge. What did you do to that vehicle?
Big dent on the side and a broken mirror.
And you did this intentionally?
Yes.
And you did not have the owner's permission to do this?
Right.
And would you agree that the monetary value of that damage was likely less than $200?
Yes.
People are satisfied, Your Honor.
So the court is satisfied with the factual basis. I will accept your plea and find your plea to be made freely, voluntarily, and intelligently. Do we have a amount certain for restitution?
Your Honor, there is no restitution.
January 27th. At what time?
9.
At 9 a.m. When you leave here, you'll go downstairs and check in with our probation department so they can get you prepared for a pre-sentence interview, okay?
Okay.
Do you have any questions for the court today? You may appear for sentencing via Zoom. Any additional matters for the record?
No, Your Honor.
Oh, you're on.
You're all set. On the record in the matter of the people of the state of Michigan versus Ali Ghiette, 4-02873, council appearance.
And then on behalf of the people.
Jacob Riley on behalf of Mr. Ghiette.
Okay, today was supposed to be scheduled for a final pre-trial and a PA 53 violation, but I think the violation he needs to be arraigned on. I don't have a note that he was arraigned on violation. Okay, having a violation or allegation of a violation here, alleging that there is reasonable cause to believe that Mr. Ghiette violated his bond between the timeframes of October 3rd, 2024 and October 18th, 2024, by making contact with Crystal Bolden by audio and video phone from Ingham County Jail. So he has the right to have a contested hearing. He has the right to be represented at that hearing by his attorney. He has the right to have the people prove the violations beyond a reasonable doubt. You understand that right, or those rights, Mr. Ghiette?
I'm sorry, ma'am. Really hear you.
You understand the rights that I just said?
Yes, ma'am.
Okay, how does he want to proceed on the bond violations?
Not guilty plea as of today.
Okay, we'll enter a plea of not guilty as to the bond violations. What's going on with the final plea trial?
And the necessary witness up here today, but it's my belief it's because of the jail calls. So I ask that you find good cause to adjourn this final plea trial for another day so we can have the violation be heard and figure out what we're doing with the final plea trial, Your Honor. But that's how the court proceeds in this court.
I'll reset the final plea trial and the bond violation to the same date. December 10th at 8. December 10th at 8 a.m. You have any questions for the court today, Mr. Ghiette?
What's going to happen exactly on December 10th, ma'am? We went in and out.
What's going to happen with between now and December 10th on this file?
Yes, ma'am.
Is that your question?
Yes, ma'am.
Yeah, there's going to be, on December 10th, there's gonna be a final pretrial and a bond violation hearing. There's nothing that's gonna happen on this file between now and then.
Okay.
Okay. You have any other questions?
No, ma'am.
Any additional matters for the record?
No, Your Honor.
Your Honor.
You're all set, sir. On the record in the matter of the people of the state of Michigan versus Brook, Beck, 24-03342, appears for the record.
Looking at that, people.
Gabriel, on behalf of Ms. Beck.
Okay, today was the date scheduled for pretrial, and this is for a stolen property charge. Is there an offer?
The offer.
There's no offer at this time, Your Honor.
How do you want to proceed, counsel?
Your Honor, for our part, we'd be requesting a second pretrial conference so that we can hopefully work towards the possibility of resolution.
December 17th at 8:30. Do you have any questions today, ma'am? We'll get you a notice to appear. Any additional matters for the record?
No, Your Honor.
No, Your Honor.
Okay, you're all set, ma'am. You're welcome. People of the state of Michigan versus Teia Drayton, 14-04243.
Sure.
Looking at that, people.
Gabriel, on behalf of Ms. Drayton.
Okay, let's see. I think we reset this matter so that she could provide some proof of insurance and a license. How are we proceeding at this time?
Well, Your Honor, my client has not been able to obtain a license as of yet. She is still paying off some fines in another county. Had spoken with Mr. Mark Perry about possibly resolving this through a civil infraction. Yes.
Your Honor, the offer, in my notes was either provide proof and dismiss or take a civil infraction. I believe the defense is going to take an impeding traffic on this case.
Yes, Your Honor.
One count of impeding traffic.
One count of impeding traffic under 257.676B, Your Honor.
Ms. Drayton, did you want to accept responsibility to the impeding traffic and pay a fine?
Yes, ma'am.
Okay, the fine is $135. When are you gonna pay?
Can I pay it in 2 weeks?
Okay, you can make payment online using the court website and your case number 14-04243. Okay,
Yes, ma'am.
you have any questions?
No.
Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set, ma'am.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Candido Lopez, 24-03333.
George and about, Your Honor.
Gabriel, on behalf of Mr. Lopez. We do have an interpreter.
Raise your right hand. Do you solemnly swear or affirm to interpret the matter before the court completely and accurately and not divulge confidential communications so help you God?
I do.
Thank you. Today's date scheduled for pre-trial for domestic violence. How are we proceeding?
Yeah, it is the parties intent to leave this separate file pre-trial.
No offer at this time?
No offer.
Run for trial December 17th at 8 a.m. Jury trial, February 10.
Final pretrial, December 17th, 8 AM. In person at the court. Jury trial, February 10th, 8 AM in person. Have any questions, sir?
Questions? I need to go out of town for the Thanksgiving holiday.
Absolutely. You need to go out of town where? What? Or you want permission to travel to Chicago to your sister's house for Thanksgiving, and when will you return? You're gonna leave what day?
Wednesday.
You said Monday. Permission granted. Any additional matters for the record?
Oh, Your Honor.
Oh, Your Honor.
Your Honor, I'd like to grab my necessary witness for the next matter.
You say you would like to what?
Grab my necessary witness for this.
I'm just waiting to see if they have any other questions. Okay, you're all set then. Thanks.
Your Honor, this next pretrial is gonna be a plea. Do you want a plea share? Can we do it orally, but plead guilty as charged?
Yeah, that's fine. No, I don't need a issue for that.
There is a Gilbert was part of that.
Okay, is the defendant in the court? This is for Williams?
Yes.
On the record in the matter of the people of the state of Michigan versus Gabriel Williams, 24-03207.
You just, they already had it. They just.
I don't know why they didn't put any stuff in there. Also appearance.
George, did on behalf of the people?
Jacob Raleigh on behalf of Mr. Williams.
Okay, today was the date that was scheduled for a pre-trial for an aggravated assault. My understanding is that he's going to plead guilty to the charge and there's a killer group.
Yep, yeah, yes, Your Honor. The agreement or the offer that expires today is a could withdraw from jail if he's guilty as charged. Otherwise, there'll be no agreement going forward. It's my understanding the defendant is accepting that plea today.
That is correct.
have the rights of rights.
I'm sorry, no, yes, I do.
Mr. Williams, that's how you want to proceed? You want to plead to the original charge? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? I have an advice of righteous plea information sheet. There's 2 sheets here. Did you go over this with your attorney? You understand all the rights here? And you want to give these rights up? That's your signature? And you understand the right to the presumption of innocence. So that means you're innocent until they can prove you guilty. You have the right to proceed to trial and require they prove your guilt by proving each element of the charge of aggravated assault beyond a reasonable doubt. You understand that, right? You want to give those rights up? You also have the right to confront and cross-examine in court any of the witnesses that they intend to call against you. You have the right to call your own witnesses or present evidence at trial that you believe show a defense to the charge being brought against you. You can remain silent at any trial and not have silence used against you, or you can waive silence and testify it on your own behalf if you want. You understand that? Anybody threatening you to get you to give all of these rights up?
No, ma'am.
Has there been any promises extended in exchange for a guilty plea to the charge?
No, ma'am.
You understand with a killer rule, that's an agreement between you and the prosecutor. I'm not a party to that agreement. You understand that? So that means I could decide that I am going to sentence you to upfront jail. You recognize that? You didn't understand that about a killer rule?
No.
Why did you not understand that?
Yeah, I understand.
You understand now, but you didn't understand that beforehand? Okay. With your new understanding, do you want to still waive your rights and proceed in this manner or not? Or do
Yes,
you-
ma'am.
Okay. Is anybody threatening you to give up these rights and plead guilty? Are you currently on probation?
I completed it successfully.
I'm sorry?
I completed it successfully.
When?
Um,
Recently?
yeah,
Okay.
all my discharge papers if you want to look at them.
And for some reason, there was a copy of your criminal record there, so I see. Okay. And you understand by entering a guilty plea, it could result in a conviction that you may need to put down on a future job application, or you may need to report this conviction on your, or to your current employer.
Yes, ma'am.
It also could have impact on your ability to travel certain places or to get immigration status in certain places. So you may want to go out the country to an island or to another country on vacation. They could deny you because of this. You understand that?
Yes, ma'am.
As to aggravated domestic violence, how do you plead?
So just to be clear, I believe it's aggravated assault.
I'm sorry, aggravated assault, you're correct. As to it's 1 count of aggravated assault, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
I should have a factual basis.
Mr. Williams, on September 14th, 2024, were you at a location in the area of South King Boulevard and West Allegan Street?
Yes.
Is this in the city of Lansing?
Yes.
Was a person named Wayne Woods also at that location?
Yes.
What did you do to Wayne Woods that would constitute an assault? In front of you, mean that you hit him physically?
Yeah.
Okay. And were you acting in self-defense at the time?
No.
And do you have any reason to dispute the assertion that he was injured by this assault?
No. I would inquire if it was an aggravated injury.
Agree.
Um,
How was he angry?
I believe, I can just state what's in the report, I believe it was noted that he had a fracture in his left jaw. Do you have any reason to believe that that's not correct?
Is that a fracture in his left jaw? Any other factual basis?
Oh, yeah, people are satisfied.
We're satisfied with the factual basis. I'll accept your plea if I your plea made freely, voluntarily, and intelligently. Your sentence date is going to be January 27th at 9 a.m. When you leave here today, you're gonna go down 1 floor to our probation department and check in with them so they can get you prepared for a pre-sentence interview, okay? You have any questions for the court today?
Sentence, that means like, starting my probation.
Well, I've not decided how I was gonna sentence you yet. Like I told you before, I could sentence you to upfront jail.
Yeah.
I don't know how I'm gonna sentence you. Pre-sentence means they're gonna interview you and provide the court with some background information and a recommendation as to how they believe you should be sentenced.
Okay.
So you're gonna check in with them so they can get that scheduled, okay?
Okay.
Do you have any other questions?
No, ma'am.
Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set.
Thank you.
Thank you. On the record in the matter of the people of the state of Michigan versus Janice Glascow, 24-02598. Council appearance.
George, in on behalf of the people.
May it please the court, Daniel, appearing on behalf of Ms. Glasgow, who is present, standing to my right.
How are you, Ms. Glascow? Okay, today was the date that we reset with sentencing. Previously pled guilty to an amended count of malicious destruction of a building less than 200 with restitution reserved at the time of sentencing. I do have a pre-sentence report. It was prepared back on October 25th. Council, did you get a copy of that?
Yes, Your Honor.
I have received one as well, Your Honor,
Okay, so we need to make corrections, updates, or deletions.
not from the people.
Yes, Your Honor, I would just make one addition under employment data. It says unemployed. She is employed now. She works for McDonald's and Wendy's.
Okay, any other updates?
No, Your Honor, thank you.
Okay, you can make allocution.
Yes, Your Honor. I would just indicate to the court that in discussing this matter with Ms. Glasgow, she's accepting full responsibility for her actions. She had a really toxic relationship with her ex-boyfriend. She's currently the victim of a felony case that he's in circuit court. He's the victim of this case. She's since closed out that relationship, and moved on. She works and resides in the Detroit area, and she's a single parent. But needless to say, she's accepted full responsibility, and she's also willing to pay the restitution amount. That's all.
The restitution amount would be the $77, is that accurate?
The restitution amount,
I only see one receipt, that's why I asked.
it's listed as $154.35.
I have the receipt that was attached to the pre-sentence report. The 77, what was the rate remaining?
Sorry, Your Honor.
What was the other for? Because I only have a receipt for $77.
Whatever's in the percent investigation report, Your Honor, the people unable to proceed to a contested, hearing to the necessary witness will not appear for that, from what the notes indicate. So whatever the PSI says, if there's no objection, people do not object.
Okay, there was, again, that were, I guess we provided a total on September 4th. 24. about labor and replacing some insulated clear glass. Again, for $77 and, oh, let's see here. No, I see, I'm reading wrong. It is $154.35. I think the balance was $77.
That's what it appears.
Okay, sounds good. So the restitution is $154.35.
In regards, there's a PA 53 for today as well. That's on my docket.
I do have that scheduled for today as well. Well, it looks like it was originally scheduled for the 12th. I don't know that it was reset. Let's see. All right, yeah, she pled not guilty. Appearing the allegation that she made contact with the party by appearing at his home and in his presence. How we proceeding? Are we having a hearing?
No, Your Honor, there is an officer present, but under the circumstance, I'll not be able to go forward with the PA 53. However, it's my understanding that there was a killabrew in this case, no front in jail. The officer is just here for purposes if the court wants to find misconduct. I can show an offer of proof under MCR 6.310. Other than that, the people are not prepared to proceed forward with the PA 53.
Let's do that.
Is there a NDOP that resulted from this? I'm reading a report allegations instead of accused grabbed a brick and damaged towards the end of the house.
My understanding, Your Honor, that's the original case. That's what we're here for. In my understanding of PA 53, there was no damage.
This here is from the report from October 28, 2024. Yeah, it says victim stated on October 28, 2024, just before 14:34. He was in the living room when he heard knocking at the door. Victim opened the door and accused walked past him and went inside. Accused and witnessed started arguing over accused property. Victim said he tried talking to the accused and they went outside. The victim said he told the accused he was going to call the police. Accused grabbed a brick and started damaging his van and his in the driveway and went to the back of the house. Victim and accused damage inside the house and the back door. So this was not from the date of the incident. This was the PA 53 allegation. Do you have a copy of the report?
I do, I'm looking at it right now. Oh.
The allegations from the date of the incident were actually from September, and the allegations was that a window was broken with a flower pot.
And then still with the, or what I said earlier, the officer is here.
You know, my question was, is there another misdemeanor pending from this?
Not what I see. I just looked earlier today. There is another one in review, but that's from back in August.
Okay, but
Not for this.
Okay. Okay. You can make allocation. Did your client want to make a statement?
No, ma'am.
Okay, I have your pre-sentence report and I have a pending bond violation as well as a copy of your criminal history, which outside of some traffic offenses. And one matter that you received HYTA status for, wasn't much on there. There was a charge of domestic violence, but no conviction. And it looks like you now have something that's under review. And I can recognize and understand that you may have found yourself in a toxic relationship. However, the circumstances and the information that's being provided as it relates to the instances that have brought you before the court mostly demonstrate you going into an area that to cause the toxicity. It's not showing me that you were in your home and you were minding your business and you were somehow provoked, but you're putting yourself in these positions. If the relationship is toxic or if it's over and you don't need to be around that person, then you don't need to be around that person. And to go over to where that person is, to engage in this kind of behavior, it's not beneficial for you. I don't know. You absolutely can.
I feel like I was just in a toxic relationship, distressed in many ways, trying to figure out to be done with this man. I'm not even in the same city as him anymore. I'm in the Detroit area, working 2 jobs and trying to, you know, stay current and continue with the no contact order and, you know, and stay on trouble. I feel like I was going through a lot dealing with him. Mine everywhere. I had to go to the hospital, you know, more than one time, injuries. I think, you know, my mind was everywhere. You know, I didn't.
You weren't in the right state of mind.
Yes,
I can
exactly.
completely understand that. Because if you were in a situation that was toxic and violent and abusive, it could cause you, first of all, you probably were not in a good state to get into this relationship in the first place. But then if you're suffering some abuse, the effects of that abuse could really help make you not be able to think about yourself, about your well-being in the manner and capacity that you would now that you're on the outside of that. I think I hope, as you stand here now, would not look at yourself as someone that would get into a relationship now that involves this kind of behavior where you all are both in and out of court for your own separate criminal convictions about the nature of your engagements that were obviously assaultive in nature. So I'm happy to see that you have relocated and I can see the transition in the file. I can see from the beginning, you were here in a shelter from the time that you were arraigned. And then, I think I arraigned you on a holiday weekend.
Labor Day.
I arranged you on Labor Day, I remember that. And you were in a shelter at the time. And then I see now, I think the last court date, your attorney reported that you were not here, you were hospitalized at the time. And then now you're here, you're working 2 jobs, you're living in a new environment or environment away from this person. And so that I think is good for you. And I think you seem to be in a much better space. And I just want you to not put yourself in a position to be back before the court over some nonsense like this. Whatever you needed to, let's say you did need to go get something that you left at his house, I'm sure it's not that important. It's not worth your safety. It's not worth your freedom, I would hope. And so You need to avoid it at all costs. You understand that? Is that a yes?
Oh, yeah, sorry.
Okay.
Your Honor,
Yes.
Before I got released out of jail, I asked the the officers, I have belongings at his house and I need to get my belongings. They told me that the police don't arrange and drive over there and wait and make sure people get their stuff. So that's the only reason why I violated, because the police told me that they don't do that. So I was trying to get the little bit of stuff I have so I can be completely done with it.
I recognize that you believe that you had a good reason to violate, but a violation is a violation. So there's a reason why we tell you not to go around the protected party. You see what happened when you did that?
Yeah. Like the police called on me.
Yeah, not just the police call, but there was allegedly some kind of interaction that was not pleasant. And so that's the whole thing. And if the police are not in a position now where they're willing to go as a peace officer to allow you to obtain your things, that's not your only recourse to how you get your things without violating. You could have come back and have Mr. Doyle ask the court if a third party could arrange to pick up your stuff. And the court would have granted that. The court would by no means ever send you or allow you to go back over there to get your own stuff. You understand that? So you don't get to make it up in your mind that this is just, so since the court said I can go with the peace officer and they won't do that, then I'm gonna just go and do it myself. It's not beneficial to you. It's harmful to you. You put yourself at risk, you put them at risk, and you ended up with another violation that you were arrested for. It's not worth it. So with that being said, I am going to adopt the recommendation of the pre-sentence report. I think that restitution needs to be ordered, obviously, but that I think you are in a position, in a place where you're outside of this environment, and you are or have restarted your life. I want to keep you on that trajectory. I don't believe further court supervision is necessary and warranted in this case. Restitution is ordered in the amount of $154.35. $75 crime victim rights fee that will be assessed with a $50 state minimum cost that will be assessed. Any discretionary fines and costs. Total $279.35. How are you going to make payments on this? Yes, that's why I'm asking you how you're going to do it.
Okay.
What is the payment plan going to be?
I could pay some today.
How much? You for sure you can afford 100 today? Is that a yes?
Yes.
When are you gonna make your next payment? Well, I'll make your next payment due a month from now. How much is that gonna be?
100.
And the balance will be due 30 days from that, okay?
Yes.
You can make payment online using the court website. I'll dismiss the PA 53 violation. Any additional matters for the record?
Oh, yeah. I don't have Ms. Glascow.
No, Your Honor.
You're all set, ma'am. Good luck to you.
Yeah, I'm a loose officer.
Yes. So Don Gonzalez here.
Yes, Your Honor.
On the record in the matter, the people of the state of Michigan versus Adon Gonzalez, 24-02626. Yes, please.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Gonzalez, who's seeking my rights.
Mr. Gonzalez is scheduled for sentencing today. I do have a pre-sentence report. It was prepared on the 18th of November. Did you get a copy, counsel?
I did, Your Honor.
Any corrections, updates, or deletion?
Not at this time.
You can address the court. One
Thank
second.
thank you, Your Honor. I did review this report with Mr. Gonzalez, and as indicated, there's no updates or corrections. Regarding the employment, he is seeking employment, is going to obviously continue seeking it, as it will be a condition of his probation. Your Honor, I have no large ask to make of this report. I think it's a fair one that accurately reflects Mr. Gonzalez's demeanor and accountability throughout this case, being that he is stemming up and saying, I did something wrong. I regret my actions that day. I should have acted better, and I'm going to act better moving forward. That being said, he's fully willing to engage in betters and intervention course that's being recommended here so that he can better assess stressful situations and make better decisions moving forward. I believe the only amendment I would ask the court to consider here is they recommended the random PBTs in the analysis. My understanding is that there's no alcohol or substances involved in the underlying charge here. So I'd ask the court to consider not ordering that condition and adopting the remainder of the recommendation, Your Honor. Thank you.
You want to say anything today, sir? Just make some things up and I'm just trying to get it back together. I reviewed the pre-sentence report and the recommendation. Recommending completion of the domestic violence program while on probation for a 9-month term. And continuing the no contact order with Jane Lopez. I recognize council has a concern about the standard submission to random PBT and or your analysis. And that there's been no information provided that there is alcohol or substance was issued at the time of this. However, that information was provided through his pre-sentence interview and information that he provided, the amount of, since he reported daily drinking since age 21, 5 to 10 drinks. And marijuana daily, 3 to 5 joints. If that's the case, it's more likely than not that alcohol or some other substance could have been a factor at the time of that incident, because he said it's a daily thing. And so the court is going to order that he participate in the standard submission to PBT and during your analysis testing, because if there is an issue that overlooked because we didn't have that information present, we want to get a hold of it sooner than later to avoid any further interaction with the criminal justice system. And I also recognize he hasn't had a substance related charge for quite some time, but that's a lot of, I think that's more than normal for a daily use to report. So that you report that you're drinking 5 to 10 drinks daily since age 21. That's a lot of alcohol. So with that being said, I'm going to adopt the report. Your sentence is 93 days Ingham County Jail, credit for 21 days. Spend the balance of 72 days upon successful completion of 9 months probation. While we're on probation, your not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance without a valid prescription, and you will be required to submit to random preliminary breath testing and urinalysis testing, and you have to pay the cost of that, okay? You're not to get any bars or nightclubs while on probation. Why are you unemployed? Why are you unemployed?
I'm currently home.
You say you're currently homeless? So you see how my question was why you were unemployed and you reported to homelessness. And I don't know that you connect the correlation. Is it likely that you're homeless because you're not employed?
Sort of, but it's not.
But is it part, do you have to have a job to pay rent?
Oh, yeah.
Okay, why are you not employed?
Too long.
Okay, why are you not employed?
Too long.
It's not too long for me. I asked a question, I want an answer.
My mother passed away and that family turned on me. Stuff you wouldn't believe.
Your mother passed away, your family turned on you. What does this have to do with your employment status?
Nothing.
So my question was, why were you not employed?
I was blackmailed at my job.
You were blackmailed at the job, your last job that you had?
Yeah,
When's the last time you were employed?
2017, I worked there for 23 years.
So you haven't been employed since 2017 because you believe you were blackmailed. And so since then you decided that you're not gonna work anymore?
I mean, I've been working, but just like I'm paid.
Okay, well, you're gonna be required to get a job.
Yeah.
You understand that? It's not an option. It's part of this probation status. You're gonna get employment or you'll just have to do jail time, okay? So I'm requiring that you provide proof of employment. And I'm also gonna require that you complete the domestic abuse program. Do you have any questions at this time? I'm gonna continue the no contact order with the protected party. I'm assuming I sent this as the bond violation.
That's correct, Your Honor. I believe that happened back at the original plea date. There was a global offer between this and another case. The dismissal bond violation.
As to probation oversight fees is a $30 per month oversight fee that you'll be responsible for. $75 crime victim rights fee plus $50 state minimum costs. What was just handed to you is the probation advice of rights. It states that you have the right to request early discharge from probation, or when you would have the right, I should say, and that would be if you were not on probation for domestic violence. If you were not on probation for domestic violence, you could complete half the original term ordered. As long as you didn't have any violations and you've done all the program, you can make a request for early discharge. You, however, are not eligible because you are on probation for a term of domestic violence. Do you have any questions about those rights? Okay, you're gonna check in with our probation department before you leave here today. I'm gonna waive discretionary fines and costs, by the way.
Thank you.
And so the 270 oversight fees plus this mandatory statutory fines amount to $395. You'll make monthly payments on that, okay? We're checking with probation before you leave here today. Do you have any questions for the court?
Would you like this sign back to you?
Yes, please. Yes, thank you. Any additional matters for the record today? You're all set, thank you. Rebecca Glascow,
Yes.
how can we help you?
I'm Bernard Greer's case manager from Community Mental Health.
I thought I seen him here. He's logged in now. Did you need to speak with him?
He's not represented by our office.
Oh, he's not. Does he have an attorney?
I'm trying to find that now, Your Honor. He was denied by our office.
Mr. Greer?
Yes, ma'am.
Okay, I do recall that you were supposed to hire an attorney. My understanding is that your request for public defender was denied because your financial information had not changed. How do you intend to proceed, sir?
I guess I'll just appeal as myself because I can't find a lawyer.
Okay, okay, and you're still currently employed?
No, ma'am, I got fired. My anger got the best of me and I got fired.
It sounds like that's a change in your financial status, so we'll have you meet with the public defender to get new information to them, okay?
Yes, ma'am.
Mr. Greer, are you having any kind of income right now?
No, ma'am.
I'll just submit the information.
Okay, she's gonna resubmit your information, okay?
Okay.
Let me reset this.
December 17th.
December 17th at 10 a.m. will be your next court date, okay, sir?
Yes, ma'am.
Do you have any questions today?
Am I in any big trouble at all with the law? Because I really like boxing and I don't want to go to jail over something stupid.
Well, sir, the only thing I have that I know of is this case that you're having pending now, which is a misdemeanor.
Okay.
That's the same misdemeanor that you were arraigned on back in October. So I don't
Yes.
know if you have anything else that's pending. And I don't know what your actual request is, but this is a misdemeanor. The maximum penalty is 90 days in jail and or $500 in fines. It's very unlikely that even if you were to be found guilty of this, that you would go to jail. up
Yes, ma'am.
front. You understand that?
Yes, ma'am.
Okay. You've appeared for all of your court dates, so continue to do that. And then it appears that by your next court date, you should be represented by the public defender's office due to the recent change in your employment status, okay?
Yes, ma'am.
Okay, you're all set. Thank you.
When is my next court date and time?
I need to you.
December 17th at 10 a.m.
Okay, thank you.
You're welcome. You seen Devontae Hanusa? Who represents him? Did you speak to him at all?
My understanding is he's expected to go into some sort of treatment program, and it might be when he is.
Yeah, I noted that he was supposed to be heading to treatment for Judge Jamo's matter. I'll hold the bench warrant until someone can confirm if that happens.
Thank you.
Deanna Parker present.
Oh, yeah.
You heard from Deanna Parker. No communication.
No, you're right, not able to reach her needs.
Yeah, it's your bench warrant. Whitney Grace present.
And here physically.
Bench warrant. Cory Grout. These are the matters of this state of Michigan versus Cory Lee Grout 21-01645 and 23-03803. These are show cause matters because it looks like you owe money. You were supposed to in 21-01645 pay $20 beginning October 28th and pay $20 per month. You must not have started the payments.
I got it caught up today. Paid this morning.
Okay.
I paid 40 this morning. Yeah.
Okay, on both files. Is that what's going on? Let's see.
That's why I wanted to, because I was confused. When
Yeah, you have two
called,
files.
They said that they put them together into
They-
one.
They
It
probably
shows
did.
that-
Just 21-01645. They put all of it on, oh, they put the payments on that one? Yeah. Because it's the oldest file, that's why. So you'll continue to make your monthly payments of $20 per month. And once the balance on the 21 file is paid off, they'll start applying it to the other one, okay?
Okay.
Do you have any questions?
No, Your Honor.
You're all set.
Thank you.
You're welcome. Have we seen Brandon Massey? Margaret Simroff? Let's see, was mistakenly told that if she paid fines, the case would be dismissed. She paid off the fines and costs, but never completed. This is, so this was the failure to complete economic fines. Yep.
I'm actually don't know what your orders are from this class. Is she non-reporting? Is she? File back. I don't know.
She's not on probation. What are you talking about?
That's what the line means.
You probably know.
I took her file to criminal to get her opinion, and they told her she needed to go downstairs.
Out of here. Mr. Sturdivant
Yes, Judge.
is here on Raciel neck.
Yes,
We're ready
sir.
on that one. Okay, on the record in the matter of the people of the state of Michigan versus Raciel Nick 24-02645, council appearance.
Virgin and having people.
Daniel Sturdivant for Miss Nick. We're both here via Zoom with consent.
Okay, Ms. Nick had a pretrial for animals abandoning cruelty to one. How are we proceeding on this?
No deferred defense.
Your Honor, I'm asking for a brief adjournment. I haven't had contact with my client until today. I think we were having technical issues with my client's phone, or it might be on my end. I'm not really sure, but she zoomed in today. I'd just like some time to go over this case with her before proceeding. There was an offer made by the people that was communicated to my client, but under the circumstances, I need more time to go over the case with her.
Sounds good. Miss Nick, can you unmute your device?
Hi, hello, can you hear me?
I said Miss Nick.
I'm unmuted.
Okay, thank you. Miss Nick, did your phone number change since September?
Yes, actually it did.
Okay, do you have the chat feature on this device?
I'm not sure. Like on the Zoom? Is that what you're
Yes,
asking?
correct. Yes.
Yes, ma'am.
Can you put your phone number in there, please? I just sent you a message. Thank you.
Yes, ma'am.
Okay, what did we send it to?
December 17th at 10.
December 17th at 10.
Okay, thank you.
Thank you, Your Honor.
No problem. Any additional matters for the record?
No, Your Honor.
You're all set.
Thank you.
You're welcome. Jennifer McEwen is present, and then who's in the jail? Mr.
Just
Cotto?
leave.
Okay, are we ready on either of those?
Miss, sorry, just like, Miss McEwen is Mr. Raleigh's. Can I get a very brief figure?
Yes. Ms. McEwen, please start your video. On the record in the matter of the people of the state of Michigan versus Jennifer Rose McEwen, 24-03-360, appearance, please.
George and on behalf of the people.
And Jacob Riley on behalf of Mr. McEwen.
Except for a pretrial, this is for domestic violence. How are we proceeding?
You know, I'll defer to defense. I was made aware that he did not have discovery at this time.
Calm down.
Yeah, Ms. McEwen, you're muted.
Hello, can you hear me now?
Yes, yes, your next court date will be December 17th.
Okay, thank you, ma'am. At what time?
Okay,
10 a.m.
10
Thank
a.m.
you.
No problem. Any additional matters for the record?
Oh, yeah. Oh, Your Honor.
Okay, you're all set. Thank you.
Thank you. What on?
So we're dismissing that.
It's general for compliance.
Record in the matter of the people of the state of Michigan versus Charles Cottom, 20-01270. Appearance, please.
Your agenda to have people.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter, on behalf of Mr. Cottom, who is joining us via polyphone.
And Mr. Cottom is present for a pretrial. This is for domestic violence.
And we're leaving this up in front of pretrial.
That's correct, Your Honor.
Final pretrial, December 17th at 8 a.m. December 17th at 8 a.m. Jury trial. February 10th at 8 a.m. February 10th at 8 a.m. for jury trial. Additional matters for the record.
Nothing further, Your Honor.
No, Your Honor.
You're all set, sir. You have questions, Mr. Cottom? I don't know, I can't hear you, but you're all set.
And I think we're ready to proceed on Tyler West as well.
West here.
He is not at this time, Your Honor. We've had some previous discussions both with myself, Mr. Mercari, and Mr. Ended, as well as the mental health court team on the 30th Circuit. Mr. West is a participant in the mental health court program there. We were trying to get this case moved to that program. However, given it's a misdemeanor, they're unable to do it. So the resolution that was reached was that there would be a dismissal of this case with continuing participation in the mental health court. If the court is willing to proceed with that today.
Why is Mr. West not here today?
That one I can't explain, Your Honor. He is unfortunately without a phone or email. This will be the first hearing I believe he's missed. I've checked in with his mental health court team. He has never missed a hearing there. So I'm not entirely sure as to his non-appearance today, but I don't have a way of reaching out to him.
Already participating in mental health court and another.
30th Circuit, that's correct, Your Honor. And we
And
adjourned his.
they have a way to contact him there?
I don't know that, Your Honor. I just know that he appears at everything he's supposed to do. There's never been a note or a issue of him missing a check-in or a court scheduled appearance there. He's completely in compliance with them at this time. And this was their suggested resolution of this case, since they can't actually take this case.
Supreme Court. I don't know why he's not here. The big part while we allow you to figure out how to contact him, if they can contact him in the circuit court matter, there's got to be a contact information. I don't see where anyone put. All I see is when he was arraigned, they said confirmed address. They didn't put a phone number or anything in there.
That's right. I have a physical address for him, just no email or phone.
You know when he checks in for the 30th Circuit matter?
I know his last check-in was on November 6th.
So
Which is the
probably
date after the last pretrial here. The day after the last pretrial here.
we were actually supposed to reset this for this to be included. It could have been some miscommunication on his part, but
Because he was told by the mental health court team that was going to be the resolution here, so I don't know
That's
if
my
things
note
have
too.
already happened.
that's my note too. So I just need a knowledge if that's the case.
I'll submit one in a few minutes, Your Honor.
Your Honor, it does indicate that Mr. West is currently staying at the House of Commons and has been since the end of October. So I don't know, it's also possible he missed his mail at his last address in Diamondale.
Okay. We'll just get a knowledge.
Thank you.
And then, is there anybody else?
I don't believe for me, Your Honor, for the morning.
I mean, Greer is not coming into that. Okay, sounds good.